One submission, my lord. No, my lord, that 6 months back, my lord, notice was issued. And in the middle of the village, my lord, that they have started crusher unit. And my lord, public have filed a writ petition and notice was issued about 6 months back. My lord, that's an urgency, my lord.
Fresh.
Any date may be fixed. No, not fresh, my lord. Notice has been issued. And my lord, 6 months back itself, therefore, my party is president.
19th.
19th. Another matter also same.
My lord.
That is, my lord, the overlapping, my lord, that in the Shumaga and my lord, in the quarry area, my lord, the deputy commissioner has granted, my lord, burial ground. That also writ petition. That is also maybe on 19th.
It can come in regular course.
19th, my lord, since or 20th, 21st, and date because the office I have verified without date, my lord.
Fresh matter.
No, notice has been issued.
Notice. So then late must have been given.
Date has not been given. I have
Not
verified.
given,
I have verified.
then 19th.
Please.
My lord, I am the petitioner in this case, matter pertaining to PL matter. Yeah, regarding the safety of elephants, my lord. The regarding elephants, this Honorable Court has
PIL.
yes, my lord.
No,
Sumota is registered and it is
PIL
listed.
not by memo.
No, my lord, already pending matter, my lord. This Honorable Court has same matter is listed on tomorrow, Sumota matter. This matter also
Then
same, my lord.
29th
Kindly tomorrow, my lord, same.
29 July. Or let it come in regular course. Either 29 July or regular course. PIL we are not going.
My lord, this
Unless it is dire urgency.
this Honorable Court has registered Sumoto that is pertaining to elephant safety, my lord. The same matter, my lord, it is, I have filed the writ petition. I am the petitioner. The state away passes through
When,
Nagarole forest, my lord.
when that
Safety of
Sumoto,
elephants.
when that Sumoto petition comes up on board, today it is there?
Tomorrow is, my lord.
Tomorrow.
It was litigated on 14/6, my lord. It
No,
is-
no intervention. Yes.
Serial number 22, my lord. I am the petitioner. Press time 2 weeks, my lord.
Which one? 2 weeks all like 29 July.
Cell number 21, happy for the appellants.
28 July, 30th July.
My lord, serial number 56, my lord.
Number 70.
Serial number?
17.
What do you want?
Senior Counsel Board of Trustees.
Pardon? What do you want? You want time?
Yes, my lord.
All right. 3 weeks.
My lord, serial number 56, my lord.
Serial number?
28, my lord, I'm part, so I've informed the petitioner side, I want 2 weeks time.
And it's one,
2 weeks.
one request, my lord, the copies of the information may be served in advance to
Yes.
us, so that we are prepared on the next.
They will be.
Date
Yes,
will
madam.
be fixed.
After 3 weeks.
And date may be fixed.
Date will be given. Yes.
My lord, serial number 56, my lord.
Yes, madam.
Connected contempt petitions release.
Online mentioning will be after this physical mention. No in
But-
between. Yes. Yes. Contempt. Not 29th of August, 29th of July.
Milord, on submission, Milord. This is a matter pertaining to review petition bench of Honorable Justice MGS Kamal, Milord. My data was given in the 9th of this month, but 9th is the not special bench. It's not possible to constitute. This is a regular working day,
You
Milord.
go to register judicial, not.
Milord, we placed Milord and to move any other date, Milord, because 9th is
That will be, date will be registered
the
judicial.
urgency, Milord, is they are putting up construction,
Sorry.
Milord.
Yes,
Serial number 74, my lord.
1 second, ma'am. We'll try.
My lord,
Yes.
move for posting. Your lordships, as per the order dated 14/6/2024, initiated a suo motu proceedings. My lord. It is with respect to saving the wildlife from illegal electrocution. We have filed a similar PIL in the year 2022. Notice has already been issued, my lord.
No,
Similar set of facts.
no intervention. I said to one of your colleague also. When it is called out, you will be, if it necessary, we'll club all together, but not by memo, no mention. Yeah.
Serial number 34, request for a week's time, my lord, I have informed the assessor.
3 weeks, yes.
Lord, in the week before last, Lordship had heard and reserved a matter relating to appointment of the chairman for the National Commission for Homeopathy. Lord, where the leadership issue is involved. Lord, the synopsis was prepared, but it left. If still there is time, I will file it, my lord. I'll pass it on. I'm great.
Friends, kindly. 19 and 20, kindly taken up along with these connecting.
Yes.
19 and 20. But these other three matters are there. Kindly take up these matters next week.
30th July. Yes.
My lord, this case was originally scheduled on 11th June.
Pardon?
This case was originally scheduled on 11th June,
Which,
11th June.
11th June, but it was missed out in the cause list on that day,
11 June.
11th June. Can we schedule it on next week?
If date is given, it will not be.
No, no, date is not given. Actually, it was given on 11th June, but it was missed out in the cause list on that day.
When shall we give?
Yeah.
23rd July?
Yeah, fair, whatever.
23rd.
My lord, serial number 56, my lord.
Yes, yes.
Connected contempt petition has ordered to be listed on 16/7, my lords.
Hmm.
Kindly may have it on serial number 56 on 16/7, my lord. I am for the respondent, my lord.
Hmm. You on time?
Yeah,
What do
yes,
you-
my lord.
what is-
Kindly have it on 16th, my lord. Contempt petition is ordered to be listed on 16th, my lord.
16.
Much obliged, my lords.
If contempt matters,
Next.
Silam-
Matters chapter 11. Start with 3 matters.
Still number 8.
No, not that. We've got a petitioner. Two other matters. Two other matters, three more raised to it. Not for it. This is part for the two other matters. 40% disability.
Two other.
Still number,
Please.
still number 9. Still number 9.
मैं कुछ ऑर्डर नहीं किया मैं ऑर्डर है डिटेल्ड ऑर्डर नहीं Who appear for it?
Yes, happy.
Government of the- Now the examination by you, medical examine, by how, panel of how many doctors?
Counseling.
Counseling is late, medical counseling is little later.
Second time when the student was examined for disability, who were the examining doctors?
The examiners I've got, the examiners are all from, Minto ophthalmology.
Panel consisting of how many number of doctors?
They have about 30, 35, 36 visually blind were there. They've examined everybody.
We are asking that how many number of doctors examined the students? Four.
Four doctors, yes.
Four doctors. Where is that?
Yes.
No, it is part of the record.
No,
No.
it's because only preliminary hearing it has come. I just got it, but I have only one
Yes.
copy. Yes, I have another copy also. I'm sorry. Down below they have signed.
It is examined by four doctors.
Four doctors. And it was examined in the institute itself, in Minto Hospital itself, because visually blind, my lord, we have sent them to the hospital because latest equipments are there.
To which hospital?
Minto Hospital. It's a government hospital, my lord.
Then
Ex-
Minister, what is the point in
Yes.
again third?
My lords, in the Minto Hospital itself, my lords, while examining the, my lord, the medical verification examination of this petitioner, they found, my lord, the 40%. My lords, he has seen that, my lords, the doctor has mentioned 40%. My lords, while uploading, my lord, that in the website of the KEA, my lord, they have shown, my lord, the 0%. My lord, even, my lord, I am having a, my lord, the reading glass. I am having, my lord, the glass also. I will keep, my lord, I have kept my lord, the petitioner is present. On seeing bare eyes, my lord, we can point out that, my lord, he is exactly, my lord, 40%, not nearly about 40%, my lord, he is having disability. On bare eyes. Lord, he can't, Lord, the 0%, Lord, the, even, Lord, the government hospital authorities, Lord, the annexure B, Lord, kindly see page number 21, Lord. They have issued a, Lord, the disability certificate, Lord, to showing, Lord, he is having 40% disability of, Lord, this petitioner, to the, Lord, his eyes, low vision. Page number, Lord, the 21, annexure B. And because of that, Lord, I have made, Lord, the Minto Hospital as a party. And my lord, this hospital should be, my lord,
Which hospital?
my lord, they, my lord, themselves conducted in the, my lord, the KA before the, my lord, the KA campus itself. My lord, the.
Now, your lordship will send them to Bowring Hospital, my lord, to the ophthalmology department, I mean, sorry, orthopedic department.
Give the
Yes,
panel of 3 doctors again.
yes.
Be
Bowring.
able to do that.
And not this also not the hand delivery of this.
Pardon?
Second petition also hand delivery of the order.
All same except name of the hospital and disability. And the kind of disability.
This is number 8.
Okay, first.
That's, I have filed a short synopsis in the matter. It may kindly see the short synopsis filed on 15/4/2024. Read it in the court itself. Last time when I argued the matter, I had filed short synopsis on 15/4/2024.
Yes.
The matter pertains to NEET for the year 2022, my lords. There are one rule of the year 2006. 9B relates to sports category. My lords, I am told 7 seats are reserved in Karnataka for sports category, 7 seats. That's an admitted fact. Then 19/9/2022 is the date when they published the notification that the list of candidates and relevant the list is 8/10/2022. Your lordship will get it at page 69, serial number 4, page 69, my lords. Insofar as respondent number 7 and the petitioner, last time I showed the honorable court, 8/10/2022. The lordship may kindly take page 69. Revised list of ranking.
This is given by them. Who is given? It's 2020, 2017 SCC, you were given?
Yes, my lords, I had given.
Yes, please.
Please. My lords may kindly see page 69, Annexure H. I stand at serial number 29. P469, Annexure H.
Yes.
This is the ranking for the sports quota, my lords. I am at serial number 29, Siri Srikanth. She is the petitioner before the court, P4 silver. She is in P4. Then, insofar as 7th respondent is concerned, your lordship may kindly turn to page 71. 71, next page. He is at serial number 129, my lords. Satvik Shivanand, 7th respondent. He is P5. He has participated. I have won a silver medal. There is a difference between that. He has participated in the national, this one, I have won. My lords, initially, On 16/11/2022, I was informed that my name is not considered, though he was P5 and he was considered and I was P4, I was not considered. In the meanwhile, a writ petition was filed before this court. Your lordship will get the order at page 84. That will apply to my matter also.
84.
84, page 84, my lords. This is by another candidate who was not selected, Aditi Rao. In that, your lordship may kindly see para 15 at page 93. Insofar as this order was challenged before the Honorable Supreme Court and certain directions are issued. Therefore, I am reading this. Para 15. He is Satvik Shivanand is respondent number 3 in this matter.
Para 16.
Para 15 may kindly be seen at page 93.
Yeah.
It is not in dispute that the petitioner has secured 4 gold, 3 silver and 1 bronze medal in the National Driving Championship conducted by the Swimming Federation of India, whereas there is no material on record to show that respondents 3 to 5 have secured any medal or cup in any events organized by the All India Chess Federation or the School Games Federation of India, which are recognized national sports federation by the Government of India. The Karnataka Chess Federation has issued an option on the entry on the query of the committee formed by respondent number 2 that chess is also considered as an international event and therefore merely for the reason that respondents 3 to 5 have participated in certain national and international championships conducted by various private organizations, it cannot be said they fall within the eligibility criteria for sports quota. My lords may skip to para 18, my lords. This honorable court sent it for reconsideration, page 95, 96, para 18.
Yeah.
In view of the foregoing analysis of the matter, we are of the considered view that the committee formed by respondent number 2, while the official memorandum dated 38/2022, under the chairmanship of Deputy Director so-and-so is required to reconsider the eligibility criteria for sports quota intersect between the petitioner and respondents 3 to 5 afresh, after giving opportunity of being heard to them accordingly the following order. The writ petition is allowed in part. Respondent number 2 is directed to take necessary steps as indicated herein above to redo the ranking list intersect between the petitioner and respondents 3 to 5 regarding their eligibility for admission to undergraduate medical professional courses under the sports quota and submit the same to respondent number 1 who shall ensure admission to the candidates based on the ranking in the ranking list so furnished by respondent number 2 and other eligibility criteria if any. Though therefore this honorable court sent it for reconsideration, my name was not there. In the meanwhile, this order was challenged before the Honorable Supreme Court. Certain directions were issued. Your Lordship may kindly turn to page 110. First order challenging this matter, page 110.
That person student who participated was given the.
Yes.
Given the admission.
Admission. The respondent number 3 was given admission. That
Where
was
is that?
challenged.
Where it is reflected that.
In the order itself, it is there. His name was considered. That is what para 15, my lord.
So, no, in our case.
In my case, I will demonstrate, my lord. Subsequently, Supreme Court has considered my case also. First order of the Supreme Court that your lordship will get it at annexure yes, page 110, challenging this order. There are 3 orders of the Supreme Court on this order by 3 different petitioners. One is the petitioner before this court. The first order was passed by Supreme Court at page 110 annexure S on 16/1/2023. Your lordship may kindly turn to page 101 to 111. We have heard
Not 16/1.
16,
16/1.
P16/1, my lords.
Before that, some order is there.
Before that, I will come back to that, my lords. That is afterwards.
Yes.
Oh, I'm sorry, the annexures are placed.
Yes, it is after.
First is annexure yes, my lords, page 111.
Yeah.
We have heard so-and-so learned senior counsel for the petitioner in SLP number 454. It is contention of the petitioner that due to the impugned order, The petitioner who has participated in chess tour, she was one of the respondents in that earlier writ petition before the division bench. In chess tournaments has been held to be ineligible by the High Court. Insofar as SLP number so-and-so is concerned, so-and-so learned senior counsel appealing for the petitioner submit. The petitioner has already been considered on merit. That is the third respondent, the seventh respondent before this court. His case is in para 2. For the submit, the petitioner has already been considered on merit for admission in Jawaharlal Nehru Medical College, Belgaum. He submits that, however, after redoing the exercise, the petitioner is found to be eligible in the sports quota, and there is likelihood that the petitioner may lose his seat in Jawaharlal Nehru Medical College, Belgaum, to which he is entitled to according to general merit list. My lords, may kindly, next paragraph, we find that apprehensions in both the petitions are misconceived. The impugned order directs the exercise to be redone in accordance with the guidelines from the authorities concerned. Page 35 of the paper book in SLP would clearly specify the order in which the candidates have to be considered. As such, we do not find any merit in the contention of the petitioner's SLP number so-and-so. Insofar as grievance of so-and-so, learned senior counsel appearing for the petitioner in SLP number so-and-so is concerned, the impugned order cannot be construed to be adversely affecting the right of the petitioner if the petitioner is otherwise entitled to general merit. That is the seventh respondent before this court. Paragraph number 2 and the last paragraph concerns the seventh respondent. Paragraph number 1 and this one concerns other respondents before the division bench. Then thereafterwards, one more candidate challenge that your lordship will get it on Annexure V, page 117.
Why you are referring to this page 111 order?
111 order is the basic order, my lords. Based on that, several orders were passed by the Supreme Court. This is the first order. Based on that, your lordship may kindly see Annexure V, page 117, second order of the Supreme Court.
Yes.
On 23/1/2023.
Yes.
We are not inclined to interfere with the impugned judgment order passed by the High Court. The special petition is dismissed. However, we clarify that while the authority is reconsidering the issue, would also consider the
Somebody else is given relief.
please, ma'am.
Some other candidate is given relief in the same circumstance.
Yes, yes. 3 respondents were there, all 3 challenged. One, the challenge is next order, I'll read. This Annexure V, they said, based on 16/1/2003 of their order, it has to be reconsidered. Now, my matter, my lords, insofar as I am concerned, your lordship will get it at Annexure R, page 109.
109.
109. Same order I had also challenged. In another order I had challenged.
This is by petitioner.
Please, my lords. This is the petitioner before this court. I had challenged another order before the Supreme Court while passing this order, second paragraph. Needless to state that if the petitioner is otherwise entitled in merits, in accordance with our order dated 16/1/2023, passed in SLP number so-and-so, the claim of the petitioner should not be denied only on the ground of delay. That is the directions in my matter, my lords. And that 16/1/2023, first I read it first.
Now this relates to which academic year?
2022, my lords.
Now there is no difficulty even if the year has changed.
Yes. Now one seat has to be reserved to our members. One seat based on the 2020 judge.
If you are, if you are to be given admission.
Yes, ma'am.
It will require supernumerary seat.
Yes, it has to be created. That is what the Supreme Court has said.
Supernumerary cannot be created, that
That-
Supreme
that
Court has
is what,
said,
that is-
because the intake is.
So how to give relief even if you are right?
No, that is in the 2020 judgment, they have stated how to give relief in these matters, my lord.
Fantastic.
2020. My lords, 2-3 paragraphs I want to read for appreciation of this matter. First paragraph, my lords. The issue that arises for consideration is whether a student a meritorious, please. 2020-17 SEC. I'll pass on. Sorry. ನಿಮ್ಮತ್ರ ಇದೆಯಾ? 2020 The directions are from, the appreciation of the matter is from para 12. But before that first paragraph, my lords, what was before the Honorable Supreme Court? The issue that arises for consideration is whether a student, a meritorious candidate for no fault of his or her, and who has pursued his or legal right expeditiously without delay, can be denied admission as a relief because the cutoff date of 30th September has passed. In such a situation, the relief which can, please, para 1, my lords, para 1. I'm sorry, para 1. Identical, sir. The issue that arises for consideration is whether a student, a meritorious candidate for no fault of his or her, and who has pursued his or legal right expeditiously without delay, can be denied admission as a relief because the cutoff date of 30th September has passed. In such a situation, the relief which can be given by the court is to grant appropriate compensation only. At the outset, para 3, my lords. At the outset, it is required to be noted that in the present case, in spite of submitting the necessary material in support of the claim of the appellant for reservation in the sports and games category for admission into MBBS course, she was denied due priority in admission into MBBS course. Therefore, the appellant immediately approached the High Court seeking admission in the reserved quota of sports and game category. However, it is found that at the time of the petition was heard, the academic session for the year in question had already commenced from 1/9/2015. And as per decision of this court, the last date for admission would be 30/9/2015. The High Court, considering the decision of this court in Jasmine Cover, observed that no direction can be issued to the appellant for grant of admission for the academic session 2015-16. However, relying upon the decision of this court in Jasmine Cover, the High Court granted compensation of rupees 5 lakhs. My lords, kindly skip to para 12. Para 12. However, the question is with respect to a student, a meritorious candidate, for no fault of his or her has been denied admission illegally and who has pursued his legal rights expeditiously without delay is entitled to any relief admission, more particularly in the courses like MBBS, the relief of compensation as held by this court in Asha. The aforesaid question is required to be considered only to the cases where 1, no fault is attributable to the candidate, 2, the candidate has pursued a right and legal remedies expeditiously and without delay, 3, where there is fault on the part of the authorities and apparent breach of rules and regulations, and 4, candidate is found to be more meritorious than the last candidate who has been given admission. 12.1. At the outset, it is required to be noted the question is with respect to a student candidate seeking admission in medical course, more particularly MBBS course. For a student candidate seeking admission in professional courses, more particular medical course each year is very important and precious. Similarly, getting admission in medical course itself is very important in the life of a candidate and even a dream of a man. In the light of the above, the question for consideration is whether compensation for a meritorious candidate who has been denied the admission illegally and arbitrarily having approached the court in time can be said to be just and equitable relief. The right to equal and fair treatment is a component of Article 14 of the Constitution. As held by this court in Asha, that a transparent and fair procedure is the duty of every legal authority connected with admissions. In such cases, denial of fair treatment to the candidate would not only violate his right under Article 14, but would seriously jeopardize his right under Article 19 and 21 of the Constitution of India. A natural corollary of declaring that an administrative act, more particularly the denial of admission, illegally and for no fault of a candidate student violates principles of Article 14 is the citizen injured must be put back to his original position. In that sense, the primary relief is restitutionary. As observed here in above, for a meritorious student seeking admission in medical course is very important in the life of student candidate, and denial of admission to a so-and-so. My lords, kindly turn to para 13, my lords, directions of the Honorable Supreme Court. After considering all this, denial of right, in the light of the discussion observations made herein above, a meritorious candidate student who has been denied an admission in MBBS course illegally or irrationally by the authorities for no fault of his or her, and was approached the court in time and so as to see that such a meritorious candidate may not have to suffer for no fault of her, we answer the reference as in redundant. Para 13.1, my lords, that in a case where candidate students has approached the court at the earliest and without delay, that question is with respect to admission in medical course, all efforts shall be made by the court concerned to dispose of the proceeding by being priority and the earliest. Then kindly see para 13.3, my lords. In my case, what happens? 13.3. In case the court is of the opinion that no relief at admission can be granted to such a candidate in the very academic year, And wherever it finds that the action of the authorities has been arbitrary and breach of the rules and regulations or the prospectus affecting the rights of the students, and that the candidate is found to be meritorious, and such candidate student has approached the court at the earliest and without any delay, the court can mold the relief and direct the admission to be granted to such a candidate in the next academic year by issuing appropriate directions, by directing to increase in the number of seats as may be considered appropriate in the case, and in case of such an eventuality, and if it is found that the management was at fault and wrongly denied the admission to the meritorious candidate, in that case, the court may direct to reduce the number of seats in the management quota of that year, meaning thereby the student was denied admission illegally to be accommodated in the next academic year out of the seats allotted in the management quota. My lords, next paragraph, grant of compensation could be additional remedy, but not a substitute for restitutional remedies. Therefore, in an appropriate case, the court may award the compensation. So such meritorious candidate who for no fault of his has to lose one full academic year, who could not be granted any relief for admission in the same academic year. It is clarified that the aforesaid directions pertain to admission in maybe a case course only, so and so. Then, my lords, in respect of postgraduate, there is a latest judgment of the Supreme Court. They have extended it that also. Paragraph 13.5, the latest Supreme Court has extended this order to that postgraduate also. 13.3 is the relevant paragraph, my lords, that mold the relief. Now, I had challenged the same in another writ petition, my lords. Unfortunately, this judgment was not placed before that bench. Now, I had represented the Chief Secretary that certain injustice has happened to me. Chief Secretary had referred the matter to the examination authority, the KEA, directing that I am P4, so seventh respondent is P5, injustice is done, reconsider. The examination authority director wrote back, no, I can't do it. I have followed the Supreme Court directions. Then the law department furnished an opinion. Chief Secretary sent it, Medical Education Secretary sent it to law department. Law department said, yes, injustice has happened to petitioner. She is P4 and respondent number 7 is P7. That communication, Chief Secretary has directed the examination authority to comply, but no compliance is made. Earlier, Supreme Court said, if I am eligible, delay will not come in the way of granting admission. That is violated with impunity. What happened, my lords? Supreme Court, your lordship, one fact I want to bring it to the notice of the court. Honorable Supreme Court passed order in my matter. I just read that order. On 10/2/2023. That date is relevant, my lords. They fixed the meeting on 13/2/2000 pursuant to original order of the Honorable Supreme Court, 16/1/2023 order of the Supreme Court. They fixed a meeting on 13/2/2023. In my case, order was passed 3 days before by the Supreme Court on 10/2/2023. I'm sorry.
Yes.
On 13th, I was in the office of the KEA informing them that the Honorable Supreme Court has directed that my case also has to be considered. Unfortunately, the committee did not consider my case and they gave an endorsement contrary to the directions of the Honorable Supreme Court. That endorsement was challenged before this court. This court said that overlooking this judgment order was passed by this court. I am seeking for that mandamus now. Please.
Lord, may I persuade your lordships to see page 133 of the writ petition, my lord, where identical writ petition was filed, seeking identical reliefs. 133 of the writ petition, my lord, filed by my learned friend. This was filed by the very petitioner. Annexure, my lord, is AA. Before that, Kindly see, my lord, Annexure Z. Annexure Z is, my lord, 131. Annexure Z, my lord. This, my learned friend read out all the Honorable Supreme Court orders. What happened, my lord, pursuant to the Honorable Supreme Court orders is this endorsement. May I persuade your lordships to see the endorsement? Yes, my lord. Seventh respondent, whom he said that, my lord, he still kept me and endorsement is challenged. That is why I am before your lordships. And he also said that he will not disturb my admission. But the endorsement, very endorsement is challenged. It is indirectly, my lord, I am now bound to explain what. The endorsement, my lord, relates to me and him particularly. The endorsement says, in SLP number so-and-so, Honorable Supreme Court video order dated so-and-so said, insofar as the grievance of Mr. So-and-so, learned senior counsel for the petitioner in so-and-so is concerned. That is myself, myself. Seventh respondent before your lordships. The impugned order cannot be construed to be adversely affecting the right of the petitioner if the petitioner otherwise is entitled to the general merit. Siri Srikant, that is, my lord, the petitioner before your lordship, submitted in an application to KEA dated so-and-so, stating that her case should also be considered as directed by the Honorable Supreme Court in so-and-so. The said order dated so-and-so states, needless to state, if the petitioner is otherwise entitled on merits, she also said that, in accordance with our order dated so-and-so, passed in so-and-so, claim of the petitioner should not be denied only on the ground of merit. Now, NEET ranking of Siri Srikant, that is, my lord, petitioner, is 8,24,000 so-and-so, while NEET ranking of mine is 63,498. Lordships may pause here. It is 8 lakh versus 63. Now, in the wake of that, my lord, lordships may see, next page, last paragraph on the next page, the cutoff ranking of Jawaharlal Nehru Medical College, Belgaum, where myself has been allotted seat, the general merit ranking is 81,439. Since the NEET ranking of seventh respondent is 63,000, kindly, my lord, mark, which is much higher than the cutoff rank of the college, it is evident that even without sports quota, he would have secured the seat in the said college under the GM category. In pursuance of the Honorable Supreme Court order in so-and-so, his seat cannot be disturbed for the sports quota reservation. The claim of so-and-so, that is, my lord, petitioner, cannot be considered for this seat as her ranking is so-and-so. Now he challenges, this itself is self-explanatory. He challenges that in the next page, in writ petition number 4855 of 23, which is in the next page. He challenges that, and kindly see, my lord, the order. Yes, I am showing, my lord, this same round of litigation took place 1 year later, 1 year earlier in February 23, saying that please allot the rank given to seventh respondent to me. Because in his writ petition, my lord, he says in the earlier, in the endorsement, it is said on merit, even if sports quota is to be ignored, for general merit quota, the cutoff rank in JNMC is, my lord, 81,434, whereas my ranking is around 63,000 something. So I should be given a seat, and Honorable Supreme Court has said, if he is otherwise entitled in the GM quota, don't disturb his seat, because even he would have got it under the GM quota. This endorsement was issued. Now he challenged that endorsement in WP number 4855 of 23. In the next page, Annexure AA, page 133, very next page. Kindly see the prayers, page 135. Very same endorsement was challenged. Lordships get. In this petitioner, that is, my lord, the petitioner before your lordships now. The petitioner inter alia has prayed following, quash the endorsement dated so-and-so, which I just read out to my lords. Then direct respondent number 1 and 2, that is, my lord, the KEA and Youth Services, to consider the case of the petitioner in terms of Honorable Supreme Court order dated so-and-so and allot the medical seat under the government sports quota to the petitioner. At seventh respondent college, same relief was claimed. Now kindly see, my lord, the result. May I persuade your lordships to see? Now kindly see, my lord, page 139. The Honorable Supreme Court, video order dated 16/1, my lord, that is extracted, which I read to your lordships. The same, insofar as 914, I'm only reading, my lord, that pertains to me at 139, my lord, in the last paragraph. My apologies. In 139, the extraction of the Honorable Supreme Court order. Insofar as SLP number so-and-so is concerned, Mr. So-and-so, learned senior counsel appearing for the petitioner, submits that the petitioner has already been considered on merit for admission in Jawaharlal Nehru Medical College. He submits that, however, after redoing the exercise, the petitioner is found to be eligible in sports quota, and there is likelihood that petitioner may lose his seat in JNMC, to which he is entitled according to general merit. We find that, this is the finding, my lord, we find that apprehensions of both petitioners are misconceived. Impugned order directs the exercise to be redone in accordance with the guidelines framed by authorities concerned. Insofar as, now kindly see, my lord, the last paragraph. Insofar as the grievance of KB so-and-so is concerned, that is, my lord, myself, for the petitioner in so-and-so is concerned, the impugned order cannot be construed to be adversely affecting the right of the petitioner if the petitioner is otherwise entitled to general merit. So that is what, my lord, the division bench holds. And kindly see further, para 9, my lord, which is not, my lord, averred now. It is noteworthy that petitioner was not a party to so-and-so as well. Petitioner filed WP number so-and-so before the court. In 2022 itself, my lord, this petitioner was before this honorable court, seeking direction 1 and 2 to consider the candidature of the petitioner while redoing the process of selection of the seats in government quota in accordance so-and-so, which was filed by another petitioner, that is so-and-so. That your lordships may ignore. Now, kindly see, my lord. Kindly now see paragraph number 12 on 145. The claim of the petitioner, my lord, this is most important. The claim of the petitioner for admission to MBBS course under sports quota was considered by KEA by an endorsement dated so-and-so. In the light of the direction contained in the order dated so-and-so passed by the Honorable Supreme Court in so-and-so, the relevant extracts. Again, my lord, the same is extracted. The petitioner, therefore, has filed third writ petition praying for the reliefs in the state. This was the third round then. Now, this is not fourth. The candidature of the petitioner has been considered in the light of directions issued by the Honorable Supreme Court order in 16-1 passed by SLP so-and-so. The admission to medical course under the sports quota is made by taking into account ranking assigned to candidate in NEET as well as her entitlement under so-and-so. In our considered view, endorsement has not been issued in violation of the order passed by the Honorable Supreme Court. Even otherwise, no relief can be granted to the petitioner at this point of time, as the last date of admission to MBBS was on so-and-so, merely because the petitioner repeatedly kept on filing the writ petitions before this court. A writ of mandamus cannot be issued to admit the petitioner to MBBS course in violation of the law laid down by the Honorable Supreme Court, which provides no admission beyond the cutoff date. Now, my lord, I halt here. The judgment cited by my learned friend, the Supreme Court judgment, my lord, in Krishna Sharda's case, says that at best, you can consider it for the next year. That was considered by this honorable court in this division bench judgment. Now, this judgment also was affirmed by the Honorable Supreme Court, which I have produced, my lord, at Annexure R6 to my objection statement. May I persuade your lordships to see my statement of objection on 13.2. This judgment, my lord, of the division bench confirmed. He appealed against that. At page 35, R6, my lord, to my objection statement filed on 13/12/23. Lordships get it. May I pass it on, my lord, for ease of reference? I'll pass it on for ready reference. Lordships got it. Kindly see this very order arising out of impugned final order dated 23/23 in WP number 4855, which I read out to my lords. Same thing was challenged. We are not inclined to interfere with the impugned judgment and the order passed by the High Court. Special leave petition is accordingly dismissed. Now, my lord, my respectful submission is, without, my lord, bothering your lordships as to what history is and what Honorable Supreme Court judgments are, a similar attempt was made by my learned friend, maybe earnestly, genuinely, my lord, in the wake of the judgment that he produced. And Honorable Division Bench said, this is third round of litigation. You have assailed everything and we have considered it. And as far as seventh respondent is concerned, there is a specific order by the Honorable Supreme Court saying that his quota should not be disturbed if he is otherwise entitled under the general merit quota. So there is no, you cannot challenge it. And the matter was closed. And this was assailed by him before the Honorable Supreme Court. There, my lord, the Honorable Supreme Court dismissed the SLP as I showed. So this is, my lord, practically fourth round of litigation on the very same relief claimed repeatedly, seeking a mandamus. Consider until the Honorable Court, my lord, this Honorable Court grants him, he'll file one more round of litigation. So my respectful submission is, my lord, Honorable Supreme Court said, at best, my lord, it can be construed as saying that if this year the quota cannot be given for some year, some injustice has been caused, kindly consider it for the next year. It is not a total blanket permission or license to, after 5 years, 4 years, whenever you can, once it has to be given, is not the, my lord, spirit of the Honorable Supreme Court judgment. That is one submission. Last submission is, if in one round he has challenged the endorsement, he has, my lord, challenged my entitlement to the seat. And that is negatived in two ways. One, by my Supreme Court judgment, my lord, where I was party, I was the petitioner. The Honorable Supreme Court said, don't disturb his quota if he is otherwise entitled. Second time, the Honorable Division Bench said, we are bound by Honorable Supreme Court judgment, his quota cannot be disturbed, don't reshuffle now. Third round, my lord, is this writ petition, which he filed even otherwise. This also is dismissed. Fourth round, the Honorable Supreme Court judgment again said the SLP is dismissed. Fifth round is this litigation. So I leave it at that, my lord. Even if this writ petition is dismissed, Lord, there will be one more cause of action for next NEET examination. That's all, my lord, is my submission.
That's I mean. Reply. Please.
My lord, I don't want to repeat what my learned friend has said. Even according to me, my lord, the entire issue was set at rest by the order, my lord, which my learned friend has read. This, my lord, the division bench order, page 133. 133. Yes, my lord. Order passed by the division bench. Because the very end, the orders, all orders passed by the Honorable Supreme Court were my lord, taken note of, and Annexure Z at page 131 endorsement was issued. That he was aggrieved by that endorsement. That endorsement he questions in this writ petition. Writ petition was dismissed. He assails the order passed by the division bench before the Honorable Supreme Court. Supreme Court, my lord, dismissed the SLP. So with that, my lord, the entire issue with regard to the earlier litigation comes to a rest. Now, my lord, your lordship kindly see the prayers made in the petition. After all this, he goes to before the government. Yes. After all this exercise was over, he goes before the government, doesn't even make a whisper about the dismissal of this writ petition as well as not the last of the SLP. He takes blood, misleads the government and also the law department, takes an order. Now that order, he wants to be implemented now at this point of time. And my lord, that writ petition which came to be dismissed, in fact, my lord, that was dismissed even without notice to the KEA. Government defended, my lord, that order, that endorsement. And this, in all fairness, this could have been brought to the notice of the government. Nowhere in the annexures which he has questioned now, this was not the reference to this, these two orders, sir. So therefore, my lord, in my respectful submission, my lord, this is not a case, my lord, again and again, he is approaching the court of the same cause of action. Could be dismissed.
I was also not party, my lord, to this writ petition that I just read out. I was not party to this writ petition also. I brought it to my lord's notice that the orders may affect me because repeatedly the petitions are being filed. I filed, my lord, then they filed an impleading application, I became a party. That's how we know. Otherwise, my lord, this would have gone unnoticed.
My lords. Regarding this filing of the writ petition and information to the government, your lordship may kindly see page 163. Now I have pleaded fraud on the part of the KEA in amendment application. I have informed the government that I had filed a writ petition and it is rejected. Kindly see page 163. I have not suppressed any facts. Paragraph number 33. My representation to the government. My learned friends are not right that I have suppressed facts. It starts at 151. It's at 163, para 33. No doubt, I'm sorry. No doubt it is true that I approached the Honorable High Court and thereafter Honorable Supreme Court by filing WP. That is the WP. I have referred to the government. It is not as if I have suppressed. Now I plead. I will demonstrate that the fraud is played by them on this Honorable Court based on the Supreme Court judgment. Kindly see, my lords, what has happened. Your lordship, kindly take to the list of dates filed by me. What fraud they have played on the division bench on earlier occasion. I was not even considered based on the Supreme Court order. My lord, Supreme Court passed orders on 10/2/2023. Your lordship may kindly see that order in my favor at page number 109 was passed on 10/2/2023. Whether my name was considered, Supreme Court said my name also should be considered. Kindly see the order of the Supreme Court. I'll read it again at the cost of repetition. This order was violated with impunity. Kindly see page 109, my lord. Second paragraph. I read it. I'll read it again. 109. Annexure R. Annexure R. Needless to state that if the petitioner is otherwise entitled in merits in accordance with our order dated 16/1/2023, passed in SLP number so and so, the claim of the petitioner should not be denied only on the ground of delay. Whether I was called for counsel, my name was considered, your lordship may kindly see the fraud played by them before they issued the endorsement. The endorsement was issued on 22/2/2023. The endorsement was issued on 22/2023. Before that, the earlier division bench based its judgment on this endorsement. Earlier to that, the Karnataka Examination Authority fixed the complaints of the High Court, this court's direction, in the Supreme Court direction, a date. Earlier order, 109. 109 contained the directions. Whether it was complied or not is a question before this Honorable Court, and whether the 2020 judgment of the Supreme Court giving directions was subject matter of the writ petition before this court. That was not the subject matter. My learned friend is wrong. That was not the subject matter of the writ petition. Kindly see page 119 for a moment, my lords. After the Supreme Court directed, they issued notice at page 119. Translated copies at 121. This notice is they issued for conducting the revised list based on the directions of the Honorable Division Bench. This was on 7/2/2023. And I was not intimated because Supreme Court passed orders in my favor on 10/2/2023, 3 days thereafterwards. I moved them on, I informed them that kindly see the consideration of the revised list at page 123. Despite the Honorable Supreme Court directing, the revised list is considered on 13/2/2023. My lords, may before that kindly come to Annexure Y, page 188, my lords. 138, 128. Page 128, Annexure Y. I'm sorry, my lords. After the Supreme Court passed orders on 10th, They had issued a notice on 7th. I wrote to them on 13/2/2023. This is very critical, my lords, that fraud has been played on me. You are aware that I was an aspirant for admission to the medical seat under sports quota, having secured several medals in national events. Unfortunately, I was pushed down in the ranking. I had to lose an opportunity of seeking for consideration of my case for admission. In pursuance of the same, I approached the Honorable Court by filing WP number so-and-so, and the same was dismissed on the ground of delay. Thereafterwards, I had to prefer SLP number so-and-so before the Honorable Supreme Court, and the Supreme Court was pleased to pass an order dated 10/2/2003 and observed that if I am entitled to, as per order dated 16/1/2023 on SLP number so-and-so, my claim should not be denied only on the ground of delay. The copy of the order dated 10/1/2000 on SLP as downloaded is enclosed in it. It is submitted that you are aware that SLP number 454 of 2023 was preferred by the candidate who sought to be displaced on account of redoing of the selection list under sports quota. The Honorable Supreme Court clearly clarified in said order that the list of candidates under sports quota for admission to medical seats are required to be redone as per norms, that is Rule 9(1)B of the Karnataka Selection of Candidates for Admission to Government Seats in Professional Education Rules. The copy of the rules. I am given to understand, para 5, my lords. I am given to understand that in furtherance of the order on SLP number so-and-so dated 23/1/2023 preferred by one Anush Gowda, the Honorable Supreme Court directed to consider his case also, and accordingly notice dated 7/2/2023 has been issued by the Karnataka Examination Authority to all the candidates involved to appear before the KE on 13/2/2020 at 11 a.m. At this stage, as an order in my case also, it is at this stage, as an order is passed in my case also, it is necessary that along with others, my case is required to be considered. The copy of the notice dated 7/2/2000 issued to the candidates and is enclosed with so-and-so. This was on 13th morning, my lords, 11 o'clock. Now, kindly turn to the previous annexure at page X, at page 123. Whether my name was considered by them before issuing endorsement. Translated copy is at page 125, annexure X. Kindly see, my name is not at all considered pursuant to the Supreme Court directions. In annexure S is critical. Proceedings about implementation of the directions of the Honorable Supreme Court in SLP number so-and-so. The translated copy is at page 125, annexure S, X. I'm sorry, I'll read, this is a short, this one. The revised list of eligible candidates submitted applications under sports quota of youth empowerment and sports has been submitted to authority concerned to so-and-so UGT NEET entrance of 2022-23 as per the order of the Honorable High Court in WP number 23265 of 2022 dated so-and-so. As concerned to this, so-and-so has filed the SLP number so-and-so in Honorable Supreme Court by challenging the order of the Honorable High Court in WP number so-and-so dated so-and-so and review petition number so-and-so. In the above cases, as per the order of the Honorable Supreme Court in SLP number so-and-so dated 16/1/2023 and SLP number so-and-so dated 23/1/2023, notice has been issued on 7/7/2000 by instructing to 4 candidates in concerning my name is not there. 4 candidates excluding my name. Sri Anush Gowda, Kushi Humbal, Satvik Shivanand, that is the 7th respondent before this court, Aditi Dinesh Rao, to present on 13/2/2023 at morning. On date 13/2/2024, candidates were present. When examined as per the direction of the Honorable Supreme Court in accordance with rules of Karnataka Examination Authority, the following list has been prepared based on 3 criteria merit list of aforesaid 4 candidates. My name is not there, my lords. Supreme Court directed on 10th that my name should be considered. Along with them, my name is not there. Then fraud played in the endorsement, my lords. My lords may kindly see the endorsement is at page 131. They are banking on that and the earlier order of the division bench. Kindly see the endorsement, my lords. This last paragraph is a fraud on this Honorable Court and the petitioner. This cutoff rank. They said, but in the endorsement, last paragraph at page 132, the cutoff rank of Jawaharlal Nehru Medical College, Belgaum, where Satvik Shivanand has been allotted seat under GM, is 81,439. Since NEET ranking of Satvik Shivanand is 63,498, which is much higher than the cutoff of that college, it is evident that even without sports quota, my lords, pausing here for a moment, his name was considered in the sports quota in the previous proceedings, implementation of the orders of the Honorable Supreme Court at page 126. His name was in the sports quota. on 13/2/2023, when they dropped the proceedings 10 days before this endorsement, they say he is in sports quota. Now, in the endorsement, they say he is otherwise eligible. If he was otherwise eligible, sports quota would be free. So 7 seats have to be filled up. I was eligible. In page 126, he is in serial number 3 in the consideration. In sports quota, he is considered in sports quota. My lords, make mark this merit, this one. He is at P5. He is at shown as P5. I am P4. He was considered under sports quota in the proceedings on 13/2/2023. On 21, cleverly they say 22/2000, without considering my name in terms of the directions of the Supreme Court, that he is considered on general merit. Now, to show that fraud was played, your lordship may kindly see the annexures produced by me along with amendment application pleading fraud. My lords, may kindly see the amendment application, amended petition, paragraph number 26, 3 paragraphs I want to read to plead that fraud was played on me. I have amended the petition. Your lordship may kindly see the amended petition filed on 15/4/2024. 3 paragraphs. My lords, may I read these 3 paragraphs? I'm sorry, my lord. 3 paragraphs. Para 26A, my lords, at internal page 22 of the amended petition, writ petition, 22A. Then I'll read the annexures where fraud is clearly demonstrated. That the admission of the petitioner to MBBS course in government quota for the year 2022 is governed by the Karnataka selection of candidates for admission. I'm sorry. Paragraph 26A, my lords, capital A. That was amended and it is allowed, amended petitions allowed. That the admission of the petitioner to the MBBS course in government quota for the year 2022 is governed by the Karnataka selection of candidates for admission to government seats in professional education institution rules. Rule 9B thereof governs the selection under sports category. Pursuant thereto, Government of Karnataka has issued Karnataka State E-Information Bulletin Admission to Medical, Dental and Ayush courses for the year 2022. Instructions and guidelines for verification of documents, online seat allotment process, a copy so-and-so. The allotment process is under Chapter 9, first round of seat allotment, internal page 52. Then para 26B. It is submitted pursuant to information sought under RTI. The first respondent has furnished information on 9. My lords, only one date I want to mention here. The endorsement is dated. Kindly reckon the date of the endorsement. I'll just refer the date 22/2/2023. Before that, they gave an RTI information. I am referring to that. The first respondent had furnished information on 19/1/2020 regarding allotment of MBBS seats under sports category for year 2022. The chart enclosed thereto showed candidate Satvik Shivanand, that is the 7th respondent, as having preference P3. On 19/1/2023, they showed that he has got P3. Thereafter, pursuant to another RTA application, the very same first respondent had furnished information on 3/6/2023, which showed candidate Satvik Shivanand as having preference P5. This was a fraud played by them before the division bench. Before the division bench in the endorsement, they said that he is considered under general merit quota. But here, I'll show that RTA annexure AP that shows that he was considered under sports quota as on 3/6/2023, not under the general merit quota. That was a fraud played on the division bench. This was contrary to information furnished on 19/1/2000. Authorities had played fraud on the petitioner in as much as she had preference P4 and Satvik Shivanand had preference P5, and the petitioner should have been allotted the seat. Then para 26. It is submitted that in the light of the endorsement dated 22/2/2003, which was issued by the executive director of the first respondent without prejudice to rights, the petitioner has prepared a chart demonstrating that if the criteria as contended by first respondent was applied, the petitioner was above candidate Lekana G and she should have been selected instead of her. A copy of so-and-so. Further, in the light of the information dated 3/6/2023, the petitioner has prepared another chart demonstrating that she is above Satvik Shivanand. A copy. All these demonstrate that by depriving the petitioner of her legitimate right, the respondent number 1 has committed gross injustice and its action is totally illegal and arbitrary. Now, this one, my lords, before the division bench, I want to just clarify annexure AA page 133. The 2020 judgment of the Honorable Supreme Court was not on record, my lords. My learned friend is not right stating that it was on record. It was not there. Last paragraph, the division bench, if it was brought to the notice of division bench, next year it could have reserved. In the para 15, that order would not have been passed. Can you see the order at para 15, page 146, my lords? Division bench non-suited me on the ground that the Supreme Court order was not violated. In fact, it was violated because my name was not on 13/2/2023. My name was not taken into consideration. Out of only 4 people were considered. I was not considered on 13/2/2000. Page 146, my lords. Operative portion of the order. This order was passed on 20th March. On that date, this court referred, in our considered view, the endorsement has not been issued in violation of the order passed by the Honorable Supreme Court. This was, my lords, factually incorrect because I have shown this Honorable Court the proceedings at Annexure X. This did not contain my name, despite Supreme Court stating my name also should be considered. This was earlier to that on page 125. So despite Supreme Court direction to consider my name on 10th order, by order dated 10th, my name was not considered. Only 4 people were considered at page 126. My name was not, Supreme Court orders were violated. Then second point, my lords, the other directions of this Honorable Court at page 146, even otherwise no relief can be granted to the petitioner at this point of time. The court would not have stated so if the 2020 judgment was on record. Now, to one more document, only one document I'll refer regarding fraud. Your Lordship may kindly turn to that amendment application filed by me on 20th March 2024. Only one document. I produced this one. My lords may kindly see the amendment application filed on 20th March 2024. Along with that, annexures I have produced. Page number 6 is the first annexure, my lords. Only one page I'll read typed copy. Page 6 is the first annexure. Your Lordship may kindly skip to page 28, my lords. Only 2 annexures I'll read. How to reconcile the matter. Page 28 is the typed copy. Page 28, how to criterion. How I come under P4, he comes under P5. Page 128. B. The following candidates will be eligible for a selection under sports category. My lords may skip to Roman 4. Who have represented Karnataka state in B games specified in schedule if and won medal cups during the 5 years of period of study in Karnataka. I come under that. That is why I am P4. He is P5 because who have represented Karnataka state in any sports or games in the B games specified in schedule 2 during the 5 years period of study in Karnataka. So he comes under 5. He has only represented. Now kindly see the next document is the guidelines at Annexure M, page 30. In that only one sentence I'll read in that document. Annexure M, A, my lords, page 30 is the Karnataka State E-Information Bulletin. In that your Lordship may kindly turn to page 80 to 81. Internal page 52. How the sports quota candidate have to be filled up, preference. Your Lordship got it at page 81, my lords. First round of seat allotment. In that, your Lordship may kindly turn to Roman 2. Roman 2. The computer begins. The computer begins allotment with the special category seats for persons with disability, NCC and the sports category. So and so. Second, B. I'll go to B. After allotment to persons with disability, seat allotment to NCC candidates holding preference 1 to 8 will be allotted under the NCC quota as per their preference, and if the preference is the same, the inter-se merit among the candidates will be considered, so and so. Then next sentence is important, my lords. Likewise, candidates in sports category in preference 1 to 5 will be allotted. That is at page 81 of the amendment application. Likewise, candidates in sports category in preference 1 to 5 will be allotted in sports quota, and where the preference are equal, the inter-se merit will be considered. He was P5, I was P4. Therefore, this criteria is in my favor. Then only one document under RTI, your Lordship may kindly see how they misled. for me to plead fraud and bring this writ petition before this court, your lordship may kindly turn to page 112. This endorsement was issued under RTI, page 112, before the this honorable court disposed of the writ petition. On 19/1/2023, your lordship may kindly see the next page. Serial number 6. Who were considered under sports quota? 7 people were considered under sports quota. Kindly see the 6th candidate, my lord, Satvik Shivanand. He is in P3. They misled. He is actually in P5. Then, after the writ petition was disposed of, I applied for finding that there is some fraud. On 3/6 that your lordship may kindly turn to Annexure AP, page 114. Annexure AP, page 114. The first page. I will read that RTI reply, my lords. This is after the writ petition was disposed of. I inquired with reference to the application dated 26/5/2023. Details of information is furnished hereunder. Now in the division bench, they said they are claiming general category under the endorsement. Here, the authority says he is given under sports category. Afterwards, I'm sorry.
Just 2 points. Lord, the one round of litigation they have withdrawn. I just wanted to show all, yes, page 102, my lord. There's no
But
reply to
everything
reply. I
falls
just
in
wanted
place.
to show. I'm sorry, my lord. Yes.
But everything falls in place after the Honorable Supreme
Correct.
Court order dated
Yes.
10/2/2000. I have not withdrawn anything. So
Yes,
after the
I am
Supreme Court-
showing much after that. Kindly see, my lord, 102. My fault that I did not show to my lords in the initial round. 102. Page annexure P 102, my lord. So after all this, which my learned friend just now argued, 102, your lordships get it, my lord. Kindly see.
No, that is before
Well,
the
one
Supreme
one
Court
thing,
order.
I'll
Please.
complete. I'll complete.
That's not fair, my lord.
I'll
That is before
complete.
the Supreme Court.
So in 2000, this is, my lord, 2022 round, and one set of, my lord, one set of facts were all over. Now kindly see 104. Yes, I was not even made a party and petition withdrawn, my lord.
Not as far as our submission is concerned, only one sentence, my lord.
I'm grateful.
Not for the NMC, only one submission. We have not had a say on that. Only one sentence. As far as we are concerned, not the Krishna Shraddha judgment which has been cited, where they speak of supernumerary post. As far as memory, I do not know exactly. That creation of supernumerary post, I think, has been either reviewed or overruled. I'm not very clear on that. But apart from that, I leave that to stand as it is. If there is, I will apprise the court. But as far as the merits are concerned, my lord, in view of the judgment of the division bench on the endorsement and the Supreme Court, the two words that come into play is res judicata as far as this is concerned. And they fall foul of whatever has been said in Krishna Shraddha's case. That you come early, all that has been said. But the logical conclusion of that is when litigation has been laid to rest, after questioning that, his only remedy on any ground is to file a review and start that process in that proceeding. He cannot file a fresh writ petition on an endorsement which has been dismissed by this division bench of this court and confirmed by the Supreme Court. Therefore, he will have to file a fresh petition, a review, if at all he has to sustain his claim, if he has a right. This court, if it sits on this, it would be only to say that it is not maintainable.
Great. Great. Contempt matters?
That's regarding translation. I placed it at the court the day before yesterday. Translated copies are last.
Seal number 1, Rajesh for PN.
For the accused in this matter, we have complied with the order.
Complaint. But at serial number 1, it is complied with, it may be disposed. It is complied, They have filed complaints of.
We have complied the order. Name.
Aishwarya.
Affidavit was filed on 31/5.
Nothing survives.
Number 5, Mr. Ramachandrayan.
Order of dismissal as questioned in the proceedings that has been set aside in Annexure A order. Direction is to implement the order. Annexure B is the confirmation of the order passed in Annexure A. And the direction was for them to implement the order and they have to grant. That is paper copy of the operative portion of the order is at page number 42, my lords. Petitioner has challenged the order of his dismissal from services with order dated 23/11/2005 and filed an appeal, and the said appeal was also dismissed on 13/2/2007. Thereafter, the petitioner has filed a petition seeking to dismiss the order question as illegal and not in accordance with law. Accordingly, the impugned order is dismissed and null and void, and they directed to reinstate the petitioner with back service with all consequential benefits therein within 2 months. This order has been confirmed in the writ petition Annexure B, my lords. By virtue of setting aside the order of dismissal, in spite of representation by me to the respondent, has not implemented to grant the benefits to me. Direction is to implement and to grant benefits. Please, my lord. The respondent is bound to implement the there is no provision for execute the order. Direction is to follow the order passed by the trial. Order of dismissal has been set aside. That has been confirmed in the writ proceedings. Now, in the in the writ proceedings, the order has confirmed.
Till number 11.
Kindly pass over the matter, my lord. On that day, your lordship has fully heard the arguments, my lord. Kindly pass over. I am supposed to file the, my lord, senior counsel is honestly before another court, my lord. Please, my lord. Kindly pass over, my lord.
File the judgments.
Judgment.
As far as we can.
And I have to file my affidavit, my lord. Kindly pass over. Please, my lord.
PL matters, seal number 12.
Tyagaraja, yes.
And for the petitioners in this case, my lord. The petitioners are agriculturists. And they are residing in the village as stated in the cost rate. Lordship. In their village, a small reservoir is there, which is the water capacity of 2423 MCFT. It's called as Boran Kanave Dam. It was built in the year 1988. There is no inflow support of the water to this reservoir. It's a small reservoir. The catchment area of this reservoir is 359 square miles. That purely depending upon the monsoon. Due to the shortfall of rain, my lordship, the said reservoir was not filled up since 20 years.
This number 13.
For the petitioners, my petitioners, section 80M of the Karnataka Municipalities Act, which was enacted in the year 2020. So till this date, we are not, my lord. Yes, my lord, yes. No, my lord.
I think.
Number 40. The green bench matter.
For the petitioner in this matter.
Number 40.
My lord, the writ is filed seeking for issuance of permits for exportation, for transportation of the mineral ore which is extracted. Now, my lords, pursuant to the Amendment Act of 2021, my lords, may I request for a date to be fixed, my lords? Please.
Number 15.
Grateful.
IR Biradar.
Only for state government. State government authority. Both the response.
Number 15. IR Biradar. 15. IR Biradar. Number 16. The Sharat Gowda ji.
Annexure A, which is a demand notice, my lord, is under challenge. Lord, there was no show cause notice, no hearing before passing this order. Lord, in 2011, my lord, I get acquiring license.
But it is covered by the judgment of this honorable court. Please.
Which I have produced along with the petition, my lord, Annexure M. Demand notice it's at Annexure A, my lord, page number 13. Translation is at page number 19, my lords.
Number 17, to Shivraj and Narali.
That's this matter, my lords, is pertaining to environmental compensation. That's my request to be tagged along with that's my request. I appear for the respondent, my lords. Similar matters are being let the other matters on the same subject matter also come up on the same day. That's the, no date has been fixed for the other day, other matters, my lords. It's pertaining to environmental compensation. We will give the numbers. Yes, my lords, 4 petitions are subjected to review, my lords. All other petitions are connected to that review petition. My lords, it had to be listed on 26th of June. Its notice may be issued, my lords.
Cell number 18. My lords. Ravindra Gajanan,
My lords, I beg to appear for the petitioner, my lords. My lords, in this matter, yes, my lords. My lords, I just want to place the memo for withdrawal. In this matter, my lord. Akshay, my lord. Yes, my lord. Lords, liberty may be reserved, my lords. Liberty may be reserved, my lords. In the liberty may be reserved, my lords. Obliged, my lords.
Number 19 to 22 urgent. Cell number 23. 23. Anish Acharya.
Here for the respondent number 1. Our senior counsel is on his legs. He'll appear.
Cell number 24. 24.
For appellant. Not in this, the appellant is the owner of 4.5 guntas of land in survey number 43, my lord. She got the land in pursuance of a bequest made by her father on 16/10/92, my lord. And subsequently, the stay, I have stayed for stay of impugned order, my lord, because if the revenue entries, my lord, at least private respondent, my lord. But in the meanwhile, my lord, let there be, because, my lord, there are 2 things, my lord. There is a clear finding that, my lord, I have been in possession and enjoyment of the property. I am constructing the residential building thereon by taking the sanctioned plan from the BBMP, my lord. In pursuance of this revenue entries, my lord, they are trying to interfere with my possession. This is a property, my lord, which has come into the jurisdiction of BBMP about 2 decades back. For that, my lord, revenue entries are being mutated in pursuance of a will, wherein, my lord, the learned judge holds that the probate got is as if it were to be decree of a civil court, my lord, forgetting the fact that, my lord, I have got a decree even prior to the execution of that alleged will. The testator, my lord, who had suffered a civil decree, executes a will in favor of the first respondent, in pursuance of which, my lord, they get a probate and they get the revenue entries mutated. So learned judge, my lord, says that you, in spite of a decree in my favor prior to the will, my lord, says that you go and challenge the probate. So that's totally illegal, my lord. The credence given to a probate, which is subsequent to a civil court decree in my favor, my lord, whether can be looked into, that is the no. At least a date may be.
So number 25, this appearance matter, the Sivraju MK.
That's the Tashildar North Taluk is present before this honorable. This is with respect to the genuinity of the Hakkupatra issued by the Tashildar. An internal communication has been issued by the Tashildar Yelahanka to the Taluk Panchayat saying that the records are not found, my lords. Lords, this Hakkupatra relates back to 1991, my lords. And it is issued by Bangalore North Taluk. As on that day, my lords, it was falling under North Additional Taluk, and now it falls under Yelahanka, my lords.
The directions issued by the learned single judge, my lord. Genuinity of the Hakkupatra, they effect kata in favor of the petitioner.
Please, my lords, we'll file. May I make one submission, my lords? Lords, this Hakkupatra, my lords, which is issued by Bangalore North. May please, my lords, I did not hear.
Why don't you respond to your higher authority, the development officer, Panchayat Development Officer, not supplying the details?
Panchayat is represented.
Panchayat Development Officer. I am appearing for the Panchayat Development Officer.
Why the Tehsildar is not responding to Panchayat Development Officer?
The Hakkupatra has been issued by the
Not the question to you. Don't interrupt when we are asking to Government Council.
My lords, we have made thorough search, my lords. The entire
We asked the Tehsildar why he is not abiding by the directions of higher authority. If he is,
Lords, we have made the search and issued the
paper?
communication that it is not available.
where is that communication?
Lords, they have themselves produced it in the
this direction came to be issued based on the communication given by the Tashildar to the Panchayat officer saying that this Hakkupatra is not available,
Where is it from?
is not available in our records.
Bring it. Bring it on.
Lords, he may be made party, my lords, Tashildar, he's not a party here in this.
Maybe. Last time we said party or not party, it doesn't matter for us when we direct the party to remain present. It is second time we are making a comment on that count and you're objecting.
We will produce
Whether
it.
party or not, we are not concerned. We are asking him to remain present. He must remain present.
He's present.
Whether party, we
He's-
know that he's present. Presence is no consequence when you are not able to answer our query. Where is that letter? If he is guilty of insubordination, then he may face the inquiry. Where is that letter? Produce on 9th. It is not available on record.
Lords, it is a part of the record, my lords. I'm
Lie. If it is so, if it is there, then show us. Ask him, he must be. You are assisting your client, he's your client. Please sit down. Please sit down. Don't assist the counsel when we are asking him. Come on 9th and again he should remain present with letter.
May I
And you
make
don't assist intervening, Mr. Counsel. You are nobody to assist when we are dealing with the government counsel and asking queries to him. When the officer is present, you are not supposed to do anything in between.
May I make one
No,
submission?
9th now,
My lords, Tashildar Yalanka is
Ninth.
the jurisdictional officer.
9th,
Lords, it falls under Yalanka.
9th, not today. In a
Please.
proper atmosphere where the counsel will not interject in the proceedings.
Sorry.
Yes,
Sorry, ma'am.
you must be sorry, Mr. We are asking the government counsel, none of your business to interject.
Sorry, ma'am.
Yes, come on 9th.
This is complaints in contempt matters, CC number 26, Mr. Ramesh KR.
Appear for complaint in this matter.
Yes.
Non-compliance of the order passed by the Honorable Court. Annexure D is the order passed by the single judge of
Where is
this.
the directions? Let us.
In page number 40, my lord. 40, my lord.
Page?
40, my
40,
lord.
yes.
Regarding Podi and Durasti is concerned, my lord.
What happened?
We have already filed the complaints affidavit on 27/6 of 2024. Don't copy.
Copy was not now.
Decided? Decided?
It is decided, endorsement has been issued. There is a claim by the forest department saying that the land falls within the reserved forest area. We
But I
issued
will
an
take-
endorsement.
I will take.
They'll have
my-
to challenge the endorsement.
my lord, I will come, I will take instruction and my lord, I will submit the matter.
Tomorrow,
Day after tomorrow, my lord.
day after.
Obliged.
Learned counsel, government advocate. Learned additional government advocate, Mr. Japarsa stated that the endorsement is issued and the representation of the petitioner is decided in compliance of the directions of learned single judge, post of learned advocate for the petitioner, Mr. So-and-so, there is for time to take instruction and confirm the issuance of endorsement put up at 2:30 on 3rd of July.
Obliged.
Obliged.
December 27, Vachan HU.
27, I appear for the ambulance.
Which?
They have filed the complaints.
27. Yes, what is it about?
My lords, it's about the execution of the RERA orders, my lords. The direction was given to the Tahsildar and DC to execute the RERA orders obtained by the petitioners, my lords.
Yes.
Now they have filed a complaints report, my lords, but the complaints has not been done fully, my lords.
So this, which
Or-
direct,
Order
the
says
direct-
that, my lords, page number 36, my lords.
directed to accomplish the implement. RERA orders.
RERA orders, my lords.
What are
They-
those orders?
My lords,
What are those orders?
my lords, I am the home buyer, my lords. I had filed a case again as the builder saying that to refund the money because I wanted to exit from the project. The RERA ordered saying that, okay, you have to refund. So the builder didn't refund the money, my
Who
lords.
have- yes.
The execution, if the builder doesn't refund the money, The execution has to be done by the DC under the Land Revenue Act, my lords. So they were not doing their job. That's why I filed an
Sir,
mandamus.
we have filed our compliance report. 6 of the properties has been attached, my lords. Out of 6, day before yesterday, 3 properties auction has been conducted.
Then they are in process of compliance.
My lords,
We are in the
my request is, my lords, let this matter be pending for another 10 days. So by then the compliance will be done. I will only withdraw the contempt petition. Otherwise, in the sense, halfway, if the matter is disposed of, my lords, then it will be stuck at that stage itself.
No.
Only, only for 10 days. By then, let them finish the auction procedure, then the money will come to me, my lords. That's the full compliance. Now it's only a half compliance.
They are in process of compliance.
Three
Another,
properties have
my request
conducted.
is another
We have conducted auction with respect to 3 properties, my lords. Another 3 properties we could not because there were no bidders. With respect to 3 properties, my lords, may I show the records to show that,
You will advertise afresh.
lords,
Auction will be reconducted for 3.
for those 3, my lords, which was not.
Date is
The
decided
date, yes, yet to be decided, my lords.
next week.
Please.
let it be for 2 weeks, my lords, because in 1 week,
Additional
they'll not be able to do
Pramod
that.
Dinication stated that in pursuance of the compliance of the directions passed by on a single judge in order dated 5th July 23 in writ petition number 6597 of 22. Some of the respondent authorities have already conducted auction in respect of 3 properties. And the amount realized shall be appropriated as per the directions. She further stated that for the rest of the 3 properties, the auction could not be held because no bidder came forward.
Please.
Also, she stated that in that fresh date for auction will be announced shortly. Full stops. It has to be observed that the authorities are in the process of compliance of the directions and that there is no willful evidence of compliance so as to constitute contempt. However, in order to ascertain the next date of auction from a put upon 15,
Please,
you give and on that they will dispose of.
please.
Grateful, my lords.
So, 28 urgent, seal number 29, Mr. Rajendra Kumar Shunde.
Wait for appellant, my lord, in this case. This is appeal is against the order of the learned single judge.
What is it about?
Lord, a backlog appointments. Lord, notification was issued for appointment of backlog. And in that, my lord, in the.
There are directions. This is contempt and period appeal both.
Yes, my lord. Appeal, my lord, I am appearing for the appellant, my lord, in the appeal, challenging the order. Lord, in the 2 posts of STs, my lord, which was reserved. One was reserved for men in the open, my lord, another was reserved for a woman. Out of these 2, my lord, there are not, no eligible women candidates were available. So that was not, Lord, selected. That post was kept on vacant. The ST men, my lord, is selected. Now, my lord, after entire selection is over, after lapse of 1 year, my lord, a representation is made by the another person, ST, my lord, who had applied, who was not selected, saying that ST woman quota, which was reserved, the post should be converted and it should be given to me because it is not available. Lord, our continuation, Lord, it cannot be done because that will deprive the woman candidate from, Lord, from getting a job. And the reliance form, Lord, was placed on some government order, Lord, years of the year 2022, 11, 2002, Lord, which is not at all applicable to the appointments in the universities, my lord, which is governed by the State Universities Act.
This will come up on 22nd.
अच्छा Still number 30. Subramanya R.
Apply. The issue for consideration is merely because of there is a change in government, whether there could be a one order removing all appointments which were made by the previous government on the basis of doctrine of pleasure.
Page 107, my lords, is a relevant clause in this matter, my lords.
After recess or any other day, whatever.
Or any other.
Any other day.
Huh? Tomorrow, day after, any date convenient to my lords, I'm at your lordships. Any day.
Huh? Can it be
Third.
on Monday, Malad?
Monday.
Monday.
Monday is which date?
8th.
8th is also. 8th.
Malad, I'm sorry, 9th, Malad. Can it be on 9th?
9th.
9th.
9th also. Not.
Interim order rest.
Interim order will continue.
If it's not inconvenient to my lords, 2:30 on 9th, my lords, so that.
You remind us, will.
Please.
Hearing for the statement.
My lords, in this matter, my lords, your lordships, my lords, may kindly please, my lords, to direct us to file a status report regarding, my lords, the properties that have been brought to auction, which have not been auctioned, and the reasons, my lord. My lord, I have placed, my lords, the same in closed cover for my lord's kind consideration. For this reason, my lord, that investigations by various agencies are going on, my lords. And on an earlier occasion, when auctions were called for, my lord, there has been some sort of, my lords, a mechanism by virtue of which, my lord, nobody is participating. But without pointing out a finger at anybody, But whatever the status is, my lord, we have brought it to your lord's notice, my lord, by filing, my lords, in the closed cover. And as far as, my lords, the maintainability of the contempt petition and the PIL, my lords, I have filed my objections. My lord, here is a contempt petition filed against such of the accused who were not respondents in the original petition. The office raises an objection as to how the contempt petition is maintainable when the accused before this court in the contempt were not parties to the original petition. So they may have to be considered, my lords. So my lords may kindly, for some time, my lords, I'll bring it to lordship's notice, my lords, as to how both the PIL is not maintainable. This is not the public interest litigation. This is some other litigation, my lords. I'll bring.
Come on, 8th.
Please, please,
My
please,
lord,
please, my lords.
My lord, can I submit? My lord, this was discussed before and then directions were given to them to forget whatever happened and make sure that 1 lakh people who are supposed to get the refund, they were supposed to comply with the orders of this court. The order is 3-year-old, my lord. It was given in 21 July for them to verify the documents or claims given by 1 lakh people, my lord. Last 5 years, the claims were given. They have not verified the claim, my lord. And the auction is much later. They're supposed to at least verify and tell the people whether the claim be accepted or not. In fact, there are people who are 70, 75 plus, my lord. People have been dying. People have been getting divorces because of issues. My lord, the whole petition is being questionable, not questionable, has already been discussed. And after that, this order was given, my lord. This is just nothing but a delaying tactics, my lord. Last 3 years, they have not completed.
Even the paucity of times, 8th.
Please, please.
My lord, please, just once. My lord, last time, my lordship had directed them on final warning to comply with the orders. And there were a lot of details to be given. Auction has got nothing to do with those details. They have filed, there are 200 plus stay orders, my lord, pending from 22, my lord. They're not even contesting those stays. So what properties, how would they auction those properties, my lord? It's just nothing but a delay, giving unnecessary reasons to delay the refund to around 1 lakh people. 3,000 crores, my lord. 1 lakh people are suffering, my lord.
We'll consider.
This was already discussed, my lord. I have given, my lord, last time they have submitted a fabricated.
The day when we'll take up the matter, we'll consider.
As for the allegation that are not
Yes.
May make a mention, my lord. Serial number 23, my lord. That is the IBC matter, section 95 matter, my lord.
That is,
Section 95 matter which was argued, my lord. Can it be taken up on Thursday or tomorrow, my lord? On Wednesday, there is some
that
inconvenience.
insolvency court,
Insolvency court matter.
whenever you want,
Thursday, my lord.
Thursday. Go, brother. Fourth, you want fourth,
Please, my lord.
you want fourth,
Fourth or tomorrow, my lord, if it is convenient.
tomorrow may not be, fourth.
Thursday.
Give for, keep there on reading.
May I seek your
Go ahead.
lordship's indulgence? Item 69 in today's list. Lords, it was actually tagged with item 30, which Learned Advocate General was appearing. Your lordship have posted it to 9th. But in this matter, we have filed an application pointing out that the term has come. But because of the interim order, lords, under the pleasure doctrine, they have continued. So we want some clarification of the interim order. Could your lordship have it tomorrow, day after, any day convenient to the court?
Day after,
Lordship,
today
please.
it is 69. You,
Item 69, lords.
Obi mujhe dena. You give me for reading. Day after tomorrow.
Yes, but once the term comes to an end, whether they could have the benefit of the continuation, lords, is this short issue for your
That day will.
lordship, please.
May I make an appeal to your lordship? Item 56.
Sixty?
I am appearing for the counsel for the respondent. Matter put tender, my lord. Award of tender is issued, my lord. Notification tender. We have paid security deposit also. Thereafter tender is cancelled. I have invested 10 crores, my lord, to purchase the raw materials.
Did you read appeal?
Yes, my lord. Writ appeal. my lord. Today it is listed at 66, my lord. 8th, 2:30, my lord, may I?
Sab lenge, lot of money. Whenever you want, we have no objection, provided
8th at 2:30, my lord.
only time constraint.
No,
Up, up.
do not take more time. Only question is this, my lord. Whether notification award is issued, tender can be cancelled. Is the question. Section 14 of the KTT Act answers it. It cannot. That is allowed the petition.
Monday? Monday.
One more request, Lord.
Mujhe
Page
dena.
number 66, Lord. 58, judicial officer seniority matter.
Seniority can wait.
Because, my lord, they are direct equities of two.
Seniority is the last thing in the court.
The difficulty is, my lord, district judge seniority of DRPR. It is allowed. Stay is granted.
We'll take up on 23rd July.
23rd.
My lordships kindly, 69, my lords, but my lordship has posted for the
Same.
after tomorrow, same thing, 69. It may come,
69,
the after tomorrow, it may come up in the hearing on IA's list, my lords, now. with my
Which
request.
is that subject?
Orders, my lords, and doctrine of pleasure term has come to an end, but day after tomorrow, my lordship
You
has posted.
mentioned, we'll take,
Hearing on IA.
we'll take up. Early, it will take up early. In the first half, we'll take.
Great.
Hello, the 68 to me.
Lordship permission, my lord.
Telecast matter. Your matter especially. You may put it. Yes,
My lordship permission, my lord, serial number 76, my lord.
6.
Yeah, the first time it's coming for the state appeal, my lord, in this case. Weeks time may be granted. Clear time may be granted.
So what do you want?
My lord, the week's time may be granted, my lord. Along with the connected main matter also there, my lord, writ appeal number 405 of 2020.
24 July. Weeks time. Yes.
My lord, in 68. Connected matter, my lord, this is. Writ appeal number 405 of 2020-24.
To be listed with 49,
405, my lord,
405,
of 2024.
24.
Stay may be extended, my lord, there granted.
Pardon?
Yes, stay is granted, my lord. The lordship has granted the stay
Stay will be
extended.
Interim stay are granted earlier shall continue to operate till the next.
Because even in number 68, the interim order may kindly be actioned. Even in 68, interim
68,
order may kindly be.
they won't time.
No, they've already mentioned, the interim order may kindly be actioned.
It will be extend, wherever it is, it will extend.
Serial number 32 and 52, my lords, may kindly be taken up together next week. Contempt and the writ of
32,
30 and 52
32 and 52.
in the same part.
20th July. 20th July is settled, 22nd July.
Seal number 11.
Filing the also synopsis. Page number.
This is that. All.
Please, ma'am.
Where is the synopsis?
Given.
You're filing the statement
Synopsis.
also.
Statement also, ma'am. Page 10. Page number 10, my lord. Document number 3. Last but one entry.
5 lakhs.
Then we have given a certificate of the Bank of College certificate. It is at page number 13, my lord, document number 4. With reference to the above subject, we hereby confirm that we have received a sum of rupees 5 lakhs on 29/12/22 from the account of so and so from State Bank of India, Murad, Maharashtra through State Bank of India, Devanalli branch, Bangalore. The amount is credited to the account of Srinivas Institute of Medical Sciences, number so and so, so and so. Same date. On last hearing date, we had filed on affidavit, my lord. There were some mistakes. The facts stated by the mother was little, there was confusion. So we are withdrawing that affidavit, my lord. The fresh affidavit is now filed.
Which affidavit you were doing?
Affidavit we have filed on, along with the bank document on Friday.
So you're filing fresh affidavit?
Fresh affidavit is filed.
That is here. Which is that fresh affidavit?
Yes, my lord. A green sheet.
Yeah, nahi hai. This one, this same?
Today it is filed now. Yes, ma'am.
Along with the bank statement.
A bank statement. Today we have filed.
कोई बता दो ना कौन सी है?
That affidavit was filed on Friday.
So we'll permit that withdrawal, Mr.
They have made a reference to.
Affidavit filed by the petitioner on 8/4/24 is sought to be substituted by filing the another affidavit today, which is today dated, which is dated 1/7/24. The fresh affidavit shall form part of the record. Whereas the earlier affidavit, though remain in the compilation of the papers of the court, shall not form part of the record.
Please.
And as is permitted, be withdrawn.
Please,
upon request of learned
Yes,
advocate. So that is all.
Yes, sir.
The reference to capitation fee in that affidavit, that is a very serious issue. That
It is
what-
their prerogative what to file, what not.
Let it-
So heard learned, what's your good name?
N. Ravindranath Kamath.
For the petitioner, assisted by learned advocate Mr. so and so and so. For the petitioner, learned senior advocate Mr.
KG Raghavan for the college, my lord. Respondent number 5.
Sri Raghavan for the.
Respondent number 5.
For respondent 5. Comma learned advocate N. K. Ramesh for respondent.
Respondent two.
R1,
Learned
AG,
additional government advocate Ms.
Mamta Shetty.
Comma at length. Learned counsels for the respective parties stated that they argued the petition finally. They further stated that the pleadings are complete and no further are required to be added or supplemented. Resort for judgment.
Please, my lord.
Well, first separate order of affidavit regarding affidavit. Filing of affidavit and withdrawal affidavit, separate order. And this is separate order. The two orders of. Or you can have it in one form. First affidavit, then reserve. Single order.
Public.
Lord, the court's indulgence, serial number 8, which was heard in the morning, I had mentioned that that judgment is no longer good law. That is 2020, 21 and 22, just for the information of the court. This is not for.
Which judgment you gave?
Serial number 8.
It should be the judge.
Serial number 8. क्या किया उसको? Reserve को? May we know your full name?
Pardon?
Full name.
Kheti, N. Kheti.
Thank you.
Obliged.
For withdrawal of appeal, number 83, the Mohammed Tahir here.
83 is for withdrawal. Day after 2/3.
So number 84,
Here for the complainant, my lord, state of hearing, they have understood that they are going to comply the order. They thought for 1 week time.
Yeah.
For the complaint, yes, government sought time, my lord.
So what is, they have short time?
In the last date of hearing, they asked.
When
time
they
for
short time in the
complaint.
morning? What is the reaction? Let us.
My lord, annexure B is the order, my lord, wherein they have, before the division bench, they have given undertaking saying that they'll be giving, they'll give posting as and when the vacancy arises. Thereafter, under the RTI, I have obtained the information, my lord, wherein on the same month, end of, this order is passed in the month of April. The end of April, there was a vacancy. Until today, they have not given the posting, my lord.
Which are the directions? Page
So, 40, my lord, 42 is the order.
42.
Yes. The third paragraph may kindly be seen.
The last time it was there, who appeared last time? You are there, madam?
83.
As and when the vacancy arises at Puttur Taluka, complaint shall be accommodated.
I appeared in this matter.
You appeared.
Yes, ma'am. Sorry, I apologize. We have already given the posting, Your Lordship, in Puttur Taluk.
Posting?
Yes, sir.
Like then
I will-
what is
will,
the order? I have not received any such.
I will,
Indeed.
I will give it to Your Lordship. I have it.
Give to them before you.
I'll give it to you now. I'll serve the copy. Apologize, Your Lordship.
Today?
I will submit it, Your Lordship. I'll get the file.
Not today. Some other
Today,
day.
Your Lordship. Today itself.
Then
I'll serve the copy.
Tomorrow. Tomorrow. Day after tomorrow.
Very.
Day after tomorrow at 2:30. In the meantime, pass over, give copy to,
Yes, Your Lordship.
to 2:30 at day after.
Very. Great.
Number 85, so Keshav Bhatt.
Weeks time or some particular time.
Why?
Monday, my lord.
Why? Why it is kept for 2:30, Mr.? It is your content.
No, lord.
When do you want?
Next Monday, my lord.
Next Monday. No. So we have not gone through the affidavit.
I've gone through the affidavit, my lord. They have not complied with the order, my lord. That's why they will submit this.
Then if
submit
you are
this, my lord.
aggrieved or they said this, you file
They
separate.
file objections on the update.
Separate, file a petition. They have completed letters. If there is nothing, then we will not unnecessarily adjourn.
But
If
kindly,
there is
my
something,
lord.
we'll grant time. Permitted to make representation
Yes, my lord.
One more.
Permitted to make representation.
within 2 weeks. Representation when petitioners consider the same outer limit. It is decided,
2 months, my lord.
decided,
My lord,
representation is decided.
not decided, my lord.
Why?
We have made representation to the accused, my lord. It was not decided. They have filed the complaints officially by saying that they have filed a revision petition challenging the order of Assistant Commissioner, my lord. That order was filed after the lapse of 6 years, my lord. Now there is no stay also granted by the Deputy Commissioner, my lord.
We are concerned the representation.
Yes, my lord. Regarding that, revision petition is the subject matter of that representation only, my lord. That representation is to enter my name in RTC.
Then if they have filed a revision, then there is no contempt.
After filing this contempt, my lord, they have preferred the revision.
They
my
are
lord.
entitled to
There
have
is
the
no
remedy.
Status quo order also.
They are entitled to have the remedy or not. It is about question of what? Some revenue records to be corrected.
Yes, my lord. My name on the RTC was deleted. I filed appeal before the Assistant Commissioner. That was allowed. Now, after filing this contempt, they have preferred revision petition before the Deputy Commissioner. After a lapse of 6 years.
Law on a single judge. You pursue there your, if you
We have
raise,
filed, hence, we have we have filed on a representation before the Assistant Commissioner that was not considered. Hence, we filed a writ of mandamus, madam. Rather, single judge allowed my writ of mandamus and directed to consider within 2 months. After filing this contempt petition, they filed that revision petition before the Deputy Commissioner. By saying that revision petition pending, hence you are not considering your representation, madam. Or else it may be directed to the Deputy Commissioner to
you
complete
appear in contempt, we can't see anything, we can't direct anything except compliance.
The endorsement has been issued in this matter where a revenue proceedings has been pending. So he has to participate in the revenue proceedings there. Thereafter, then he can take up the challenge.
Law on a single judge by order dated
December 2023.
14 December 22. Required the respondent concerned to consider and decide the representation within stipulated time. The representation of petitioner was with regard to making khata and RTC in respect of land in question. Full stop. The compliance affidavit is filed pursuant to issuance of notice in this contempt petition, in which the aforesaid direction was brought under jurisdiction. brought for implementation, stating inter alia that the issue is being agitated by the authorities by filing revision application. Necessary endorsement dated 4/6/24 is passed in compliance of the directions of learner single judge. Also, passing of endorsement stating the aforesaid fact, namely that the revision application is filed. It marks the compliance of the order. It is stated in the endorsement dated 4/6/24 that in view of the pendency of the revision, it is not possible to take action as requested by the petitioner, and that after the deputy commissioner decides the case, a necessary action in law will be taken. Full stop. In the aforesaid view, it could not be said that any contempt, much less any willful contempt, is committed by any of the respondents. Rather, the direction to decide the representation is complied with. Contempt proceedings, present contempt proceedings are required to be closed. Accordingly, the petition is dismissed as not surviving. It is open for the complainant to participate in the revision authority and raise his defenses in accordance with.
Number 86, P. Nanjareddy, 86.
This was 85. Earlier 85. 86 not there. Day after tomorrow at 2.
Number 87, to Muralidhar HM.
For the petitioner. This case, the government has filed a memo stating that as per Rule 15, the minimum extent of land should be 2 acres, and therefore it cannot be considered. My respectful submission is that cannot be correct, because for next year, my application has already been considered as saved application.
You are challenging what?
I am seeking a writ of mandamus to issue lease deed pursuant to the license granted. Kindly turn to Annexure D.
Annexure B.
Annexure D.
B or
License has been granted on. D.
Yes.
Annexure D. Yes.
Annexure
D. In page 48.
page?
In page 48.
48.
Yes. It is dated 3/6/2019. License has been granted to me. But kindly see the condition C in that. Quarrying work should not be started based on the notification. Quarrying should be started only after executing this deed or license deed. After issuing this, they did not issue lease deed. That is why I filed the petition before this honorable court. And this honorable court passed the order directing me to go before the regional authority. And as per Annexure A, in page 16, the regional authority has passed a detailed order. In that order, I request my lords to kindly go to Para.
Page?
Page 31, my lords. Annexure A. This is the order passed by the regional authority. I will only take my lords to the relevant portion at paragraph 5.16.
So this is in your favor?
Yes, see, in view of the, in the same, it can be fairly held that the application of the petitioner dated so 22/2000 certainly falls under the category of saved application in terms of 8(2) of the Karnataka. So therefore, my respectful submission is the memo filed by the government is not correct, because my application is already treated as saved application. License has been granted long back. All that they need to do is execute lease deed.
Mr. Mahendra, something appears to be in their favor, page 32.
No, my lord, in the, my
And the lease is cancelled? No,
lease is not cancelled.
not cancelled.
Not cancelled. The order of the revisional authority in page number 32.
Oh.
32.
Oh. May be allowed subject to further.
Subject to further consideration by the competent authority in accordance with law.
Correct.
It is for the competent authority to decide. You last may kindly come to page number 21. Before that, page number 20. No, in fact, notification was issued in favor of the petitioner. In page number 19, last para, pursuant to the said notification, approval of quarrying plan was also granted as requested by the petitioner. However, one of the condition imposed for such approval was production of certified copy of environmental clearance certificate given by the State Environmental Impact Assessment Authority, Karnataka. The said state level committee has issued environmental clearance certificate in favor of the petitioner on 29/11/2019. Then, Lord, in page number 21, it is relevant to note the paragraph 3 to 7 of the counter affidavit filed by the senior geologist, which reads under. I state that pursuant to the order of this honorable court, I have issued the notification dated 3/6/2019 granting quarry lease in respect of 1 acre of land in survey numbers so-and-so Algera village, Yadgir Taluk. I humbly state that inadvertently in a notification, it is mentioned that grant was made under Rule 32 of KMMCR rules. Rule 32 pertains to Patta land. This is not a Patta land. A copy of the said notification is enclosed as annexure R1 for the kind petition. Therefore, the lease was not granted. Now, Lord, the present rule contemplates, which came into effect from 17/3/2023, 17 January 2023, the minimum extent shall be 2 acres. Your last may kindly peruse the order passed by the competent authority, which I have produced along with a memo dated 28/6/2020.
Where you are going? Memo, where is memo?
Memo 28th June 2020.
So this is the order by competent authority.
Competent authority. Competent authority rejected the application on the ground that minimum, as per 15A, Rule 15A(1), minimum required area is 2 acres. Now, if at all he is aggrieved by this order, Lord, he has to prefer a revision. Even otherwise, rule doesn't permit.
I am pursuing the matter since 2014.
That is a different thing, Mr.
My application is of the year 2014. This is the third round of litigation. And when I was driven to the revisional authority on the last occasion, revisional authority has passed a speaking order that my application should be treated as a saved application under 8B. This is not challenged by the government. And now the rejection of my application doesn't arise because the license has already been granted as per annexure D. All that they need to do is issue lease deed to enable me to commence the quarrying work. At this stage, they cannot say that in view of the amendment, minimum extent should be 2 acres, therefore we can't consider the.
Why?
Because it should be considered a saved application. Under saved application, no such minimum extent is required.
What is the provision for saved application?
Pardon me?
Which is the provision for saved application?
8B.
8B.
Yes. And the divisional authority.
But
has-
revision is also available.
Pardon me?
Remedy of revision is available.
Under what circumstance revision remedy is available?
Eight.
8E, after amendment. In the said rule 8B, the following shall be substituted.
Read the, please read. Read it,
Amended portion, amended.
whatever is applicable.
Status of application, notwithstanding anything contained in chapter 5(4)(a). All applications received for grant of lease prior to the date of commencement of Karnataka Minor Mineral Concession Amendment Rules of 2000 become eligible, including the application received for grant of mining lease.
Mr. Mahendra, where is the provision of saved application?
Saved application was in the year 2016,
Yes.
8B1, B2, A1 to D. Now, that is not then, that has been repealed.
If my application.
That is not
That is not then, not
because of 23 amendment.
repealed by substitution.
At that time, it was available for him or not?
Yes.
That time it was available. That is why I have shown them lot this order.
It operated in their favor. That time, that rule operated in the favor of petition.
No, that was a wrong notion. Under the wrong notion, competent authority held that it is a saved application, presuming that his area is a patta land area under Rule 32.
Chapter
And
chapter 4A is related to patta.
32, Rule 32.
4A. Chapter, what is chapter 4A? Notwithstanding anything contained in chapter 4A, all applications received from the grant. 4A is some condition.
4A is for grant of lease or composite license by auction.
By this amendment.
But go to your page 32.
32.
Page 32, annex area order.
Please. Lord,
The order says that the application for 1 acre was saved in terms of Rule 8B. So that saved aspect is final.
saved, however, it is for the competent authority to decide. In the discussion part, you'll ask me kindly see, page number 28. 28, discussion and reasoning.
Yes.
Lord, may I read 5.2? However, in terms of Rule 8B2, certain of the applications which were given prior to 2016 amendment were saved. And Rule 8B2, in terms of subsection A, B, C, D, D1, provides for condition for the application to be saved. These conditions have to be fulfilled. Admittedly, the application of the petitioner falls under the aforementioned criteria, taking note of the same endorsement dated.
One sec. So it could not have been the saved
No.
because of patta land. Because of it is not a patta land.
Not a patta land, and it is a blood, a land cannot be granted under Rule 108. It is mentioned in page number 29 also. Rule 108I of Karnataka Land Revenue 1984 reads as under. Notwithstanding anything contained in this chapter, land assigned for special purpose under section 71 of the Act and the land described in revenue records as Devarakadu, Urduve, Gundutopu, Tank Bend, Food Karab, Hall, burial grounds and such lands which in the opinion of the government is required for public purpose shall not be granted.
It is falling
This
under-
is not Devarakadu. It falls under this category of land.
Devarakudu.
Yes.
Where from we get that is Devarakudu?
Then, Lord, page number 35.8. In the light of above, Revenue Department has opined that in respect of Parampoku government land,
It is in
page
Kannada.
number 35.8.
Kannada.
English.
30. 5.8.
Parampoku government land, Kasakala Gunte.
This land is Devarakudu land. Where from we get?
That, Lord,
That is only the opinion of Revenue Department. with the online
because
data.
where, that
the
is where,
law.
that is where it is situated.
That is what matters. Opinion of the Revenue Department. What else will matter? And you are not challenging that aspect.
Yes.
This is one aspect of the matter, Lord. So far as if he is relying on the amended rule, 15A clearly applies. Area criteria, Lord, minimum extent clearly applies. Therefore, the competent authority is right in rejecting the application of the petitioner.
Heard learned advocate,
Area of criteria doesn't apply to me because.
Mr. So and so. Heard learned advocate, Mr. So and so for the petitioner. And learned government advocate, Mr. S.S. Mahendra for the respondent. In this petition filed under Article 226 of the Constitution, the prayer of the petitioner is to direct the respondents to execute and register lease deed in favor of the petitioner pursuant to the grant of quarrying lease dated 3/6/19 in respect of survey number 95 of Heligera village, Yadgiri district, to the extent of 1 acre, in terms of order passed by respondent number 1 authority in revision petition number 166 of 22. The operative paragraph of the aforesaid order dated 1/1/22 passed in the revision proceedings reads as under. Same, page 32.
Right.
Yes.
Page 32, paragraph 6.1, quoted portion. Full stop. The order mentions that the application of the petitioner for grant of co-release may be allowed subject to further consideration by the concerned competent authority in accordance with law. Paragraph. While learned advocate for the petitioner would harp on the basis of the aforesaid order that the case of the petitioner and his application is liable to be treated as saved application in terms of Rule 8-B capital into bracket 2 of the Karnataka Minor Mineral Concession Rules 1994, learned government advocate pointed out the stance taken by the authorities in the revision proceedings. Post of the senior geologist filed affidavit, counter affidavit, paragraph. The counter affidavit read as under, as could be extracted from paragraph 2.11 of the divisional order, page 21 of this read part. Full stop. It could be undisputedly when paragraph, when learned government advocate pointed out that as per the aforesaid affidavit, the notification granting quarrying lease in respect of 1 acre of government land in the said survey number inadvertently mentioned that the grant was made under Rule 32 of Karnataka Minor Mineral Concession Rules into bracket KMMC rules. The land it was submitted was not a patta land, whereas Rule 32 under which it was granted was related to patta land. Therefore, the entire basis of grant was erroneous in law. The factum that the land was not a patta land could not be disputed by the petitioner. Furthermore, paragraph, learned government advocate invited attention of the court to, where is 108 quoted?
Page number 29, para 5.6.
To Rule 108 of the Karnataka Land Revenue Rule 1964, which provides that certain lands cannot be granted. Rule reads as under, and quote, page 29 of it. Full stop. It is stated inter alia in the aforesaid rule that the land which is described as Devara Kadu land, etc., would not be granted, cannot be granted. The land under consideration is Devara Kadu land. Full stop. When it was when learned advocate for the petitioner was confronted with this aspect, he was entirely at his receiving end to be able to submit only that it is the opinion of the revenue authority. However, when the authorities has classified the land to be Devara Kadu land, the bar of Rule 108 applies that such land could not be granted. For all the aforesaid reasons, no relief could be granted to the paragraph, taking into account, not before that, taking into account all the aforesaid aspects, the competent authority, that is the senior geologist, the Department of Mines and Geology, has passed order dated 11/6/24, which was produced by learned government advocate by filing memo dated 28/6/24. The said order takes into account that the minimum prescribed extent for grant of quarry lease is 2 acres, whereas the petitioner had applied for 1 acre. Full stop. This becomes additional lawful ground to deny the relief to the petitioner. In the aforesaid facts and circumstances, no relief could be granted to the petitioner in the present petition. The petition is meritless. It is accordingly dismissed. '87.
Number 88, HP Gangesh Gowda.
Here for the
88.
the contempt petition, my lord, I am for complaining. But for the employees, my lord, in the writ appeal filed by my lord, challenging the order passed by the single.
My lord, my instructions are that the respondent had placed the subject before the Board of Directors meeting held on 28/6/2024. And the minutes of the meeting is still awaited. Therefore, I pray for a week's accommodation to place the resolution of the meeting and also the affidavit of the respondent, my lord.
Small payment is due to the employees.
We'll keep it on 16th.
Much obliged.
Number 89, Mr. D.N. Manjunath. 89.
What is it about? Why it is kept at 2:30?
My lords,
44 years delay.
my lords, this land acquisition appeal, I could have understood if it is some other matter. Now the Supreme Court consistently has held
They
it.
replace more rigorously in land agreement.
True, my lord.
Challenge land agreement.
Your lordship may kindly see, all my entire extent of land has been taken away without payment of compensation. Not even a pay has been paid to the land loser. And there are three judgments of the Supreme Court which says that there is a duty cast upon the authorities to call upon me to say, have my say in the matter and also give me compensation. The Supreme Court has gone to the extent of saying that they should come and pay the land loser. I'm not expecting them to pay the money to my house. But same time, a land loser's right should not be taken away by this. A valuable property of mine has been taken away by the authorities under the garb of acquisition without payment of compensation. I got 3 citations of the Honorable Supreme Court, which says that an opportunity has to be given to the land losers. Because even it is otherwise violative of Article 300A of the Constitution. Let them file their objections and let me be heard in the matter. Whether I'm entitled to compensation or not is a question of, ultimately is a matter of fact. I'm not seeking for quashing of the notification or anything. I'm only asking for compensation, which I'm legally entitled to. Delayed latches should not come in the way of a person losing his land. He's a retired person from the Hindustan Aeronautics. So the engineer, he could not, his father was looking after. Unfortunately, he's lost his father in paralytic stroke. Let them give an opportunity. I will have my say in the matter. If I am entitled to compensation, let them pay it. Otherwise, no. It's only for a writ of mandamus.
What is prayed in this petition filed under Article 226 of the Constitution is to require the authorities to produce the records, require the respondent authorities to produce the records pertaining to the proceedings initiated by the respondents in LSC land acquisition case number 692 of 1978 and in land acquisition case number 228 of 1982. Full stop. The petitioner has further prayed to direct the respondents to initiate proceedings to pass the award under section 11 of the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 9/2013. On a single judge, dismiss the petition by observing that the properties of the petitioner was acquired by preliminary notification dated. The preliminary notification passed in the year 1977 and the final notification was issued in the year 1978. It was recorded that there was a delay of 44 years unexplained in the writ petition. Full stop. When the court confronted the senior advocate, Mr. So and so, appearing for the petitioner with the aspect of huge and inordinate delay, he could only point out the averments in paragraph 33 of the petition, in which it is inter alia averred that the petitioner came to know for the first time in the week of 2018 that the compensation was not paid. The petition was thereafter instituted. In institution, the petition subsequent to the so-called knowledge of the petitioner also, subsequent to the claimed knowledge of the petitioner also, subsequent to the petitioner's knowledge, claimed to be in 2018 also, there has been delay of 3 years, full stop. 44 years is too long a time to maintain a legal action, full stop. With passage of such protracted time, the right to relief is lost, full stop. The jurisdiction under Article 226 of the Constitution is not liable to be exercised to entertain the stale and virtually dead claim as regards the paragraph. Grievance about the compensation is concerned, it is kept open for the petitioner to make a representation to the competent authority respondents. Full stop. The competent authority shall examine the said aspect about the compensation and take appropriate decision in accordance with law. Full stop. Without expressing any opinion on the merits, this petition is dismissed, subject to above limited observation. Same. Both are same.
Serial number 40.
Sir, which is the other matter? Yeah, 88, 89. 89. So both are same, two petitions, both deep. In both 44 years? Same judgment. I'll just correct it, draw my attention.
Serial number. With the kind permission of my lords, serial number 49, my lords, is a action taken by Pollution Control Board directing cancellation of my operation. Today, the other side has just placed a memo on record which says that it has been deferred, the decision. So the matter can be disposed of if my lords could have it on any day, my lords.
Day after tomorrow, 2:30.
Grateful. Grateful.
Lord, serial.
Serial number 74.
You are right. Today it was,
Therefore, the petition.
today we had a less time.
It was not heard.
Who is opposing you, madam?
Appear for the appellant minutes.
We'll take up,
Even
you
rectified
mean.
the office objection.
What is the matter?
My lords,
My lord, I had availed
Please.
gold loan from the Muthoot Finance, my lord, and they have auctioned the gold in spite of the stay, my lord.
stay was not operational.
Stay.
Yeah.
Permission is there.
Lord, during COVID
Permission is
pandemic,
there,
my
yeah.
lord, stay was granted, my lord.
Next week ಅಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಒಂದಿತ್ತು.
Tomorrow at 2:30.
At the top of the list is
In the recess, after recess.
2:30.
2:30.
Serial number 75, my lord.
Serial number 42, my lord.
What next?
My lord, serial number 63 and 64, my lord,
36,
pertain to
36.
medical admission. Now exams have been announced, my lord.
Serial number.
Matter is little urgent, it may be taken up. on-
Exams.
Yes, first year, my lords. It is a writ petition, my lords, before my lords.
When it is started?
My lords,
Exams are starting when?
that is from 4th onwards, my lord.
4th onward,
Yes, my lords. My lords, it may be taken on tomorrow or day after, my lords.
day after.
Serial number 75.
Serial number
46, 47 and 48 similar to serial number 62 and 63 balance. Kindly have it removed. Serial number 46, 47, 48, my lord, similar to serial number 52 and 63, where the date has been taken. So kindly have it.
No, serial number
Serial number
75, my lord, I
42,
made a
my lord.
suggestion on Thursday.
42 next week, my
My
lord.
75 is the hookah matter, my lord, the batch matters together. My lords are directed to be listed today. My lords, we are also asking for interim relief. My lords may kindly have it tomorrow or day after, subject to my lord's convenience, my lord. At least a date may be fixed.
Sorry.
My lord, 75.
My lord, serial number